Thank you, Your Honor. As I mentioned to the court, I am asking that Mr. Johnston be allowed to be released to inpatient treatment. That is a priority of his. He acknowledges he is eager to get treatment. I know Mr. Johnston is not happy about my request for an adjournment of the PCC, but I think it's important because I do think there is some additional discovery that we should see before he makes a decision whether or not to waive his exams.
So let's pause right here. The defense wants Mr. Johnston released to inpatient treatment despite pending concerns about his behavior. What do you think? Should treatment override courtroom defiance? Drop your thoughts in the comments. This one's tricky.
Adjourn probable cause conference June 26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. I did just want to repeat the response, please.
Yes.
We did discuss this at the bench. I understand that at our last hearing, the court was very clear with Mr. Johnson about the fact that there was no contact with the DV victim related to this other case, and who's also involved in this case as well. And his phone privileges were revoked at the jail, and that he was having absolutely no contact with her whatsoever, including he contacted third parties. Well, he's attempted to call her 6 times.
6 attempted calls. And third-party workarounds. That's not a misunderstanding, that's a strategy. And using someone else's jail pin to do it. That's a violation on top of a violation. This isn't just defiance, it's calculated.
And also use third parties to make requests that they get in contact with that same victim, tell her that he loves her. I can make a further record of some of the comments, but Mr. Johnston is apparently under the impression that because he had
affectionate with all the FS, you know the judge is fuming when sarcasm makes the bench. And when judges start throwing shade, somebody's in deep.
And still has consensual contact with her in his other case, that trumps any orders given by this court. I would ask that the court make it very clear, since in one of those calls he stated that the county, quote, fucked up his orders. And I won't repeat the comment that he made about Your Honor, apparently in this case, but I'm
sure it was very affectionate, so go ahead.
Sure. Affectionate with all the F's. Mr. Johnston is under the impression that, again, there are erroneous orders made. I would like the court to be very clear with him that no matter what order he has in any other case, a revocation of phone privileges, as well as no contact with this victim, including third parties, regardless of this location, including should he be released to inpatient treatment, as counsel's order states, all prior bond conditions remain in full force and effect. That does include contacting this victim, including with third parties. While we may not have a recording from him while he's in treatment, it will still be apparent to us because, quite frankly, Mr. Johnson has been anything but subtle since he's been having this case pending. So I'm just asking for a reminder of those conditions. And I don't have any issue with the release of treatment. However, I would ask, I'll just leave it at that. I'm asking the court for now.
Thank you. I just received the transcript of these calls, actually, just very brief, not too long ago this morning. I'm going to have a very detailed and thorough meeting with Mr. Johnson later today about his bond conditions. He does have 2 different cases. Obviously, she's not listed.
Quick legal note. When a judge issues a no-contact order, it's not a suggestion. It's an enforceable court directive. Violating it, even through third parties or sneaky jailhouse tactics, can trigger new charges. Ignorance doesn't fly.
As a victim in this case, it's the circuit court case where she's the victim. And so I will make it very clear with Mr. Johnson in our meeting later today. I would request the actual calls from the state instead of just the transcript.
Mr. Johnson, you understood what I ordered? Not asking whether you like it or not. You understood what I ordered?
I kind of understood, Your Honor.
Yeah, what's the kinda?
I've never been in like court like this before, so I'm not I'm new to this, like being in trouble and stuff like that. So I'm not all familiar with the terms or wording and ways of effect of. I watch a lot of court TV, yes, but I don't understand personally, no. I do have like a question of like what does a no contact order mean, Your Honor? Like, if you can, like,
No contact order means that you are not to have contact with that named individual, either directly or indirectly through third parties in any way whatsoever. You are not to have contact via any electronic communication, whether it be telephone, email, social media, or anything like that. And you are also not to mention them on any social media platform. Is that clear enough for you?
yes, Your
And
Honor.
understand something. I don't believe in coincidence. So if there's contact, I'm going to believe that you purposely did it, either yourself or through some third party. Because even after I ordered it the last time, and I don't think you don't know as much as you're trying to pretend before me that you don't know because of some of the stuff that you were saying going out of the courtroom. Also, if true, your behavior indicates that you are sophisticated enough to get somebody else's pen to try to make communication in an indirect fashion. So you understood exactly what I said. You just didn't like it. So hopefully now you do understand. Do you?
Yes, sir.
Do you have any other questions regarding what I mean by no contact?
No, Your Honor.
I don't want to hear any more that there is any type of use of somebody else's pen to do some direct or indirect contact with the victim because
So here's the pattern. The judge just laid down crystal clear rules. And now we're jumping straight into a bond hearing for another defendant, Mr. Frell, who, wait for it, also violated court orders. Deja vu, anyone?
you're not supposed to be making phone calls at all. You've lost that privilege. Anything else from either side? June 26, 2025, 9 a.m.
Your Honor, would the court consider a 1-week adjournment, or is that not enough time?
If you want, if that'll work for you. If you're trying to get I don't know about the discovery. That's the only thing I'm trying to.
Understood. Do you know?
I'll give you the 1 week.
Okay.
The 911 public prosecutor.
June 12th,
Thank
2025,
you.
9 a.m. Bond is continued with its condition and my admonition that you need to follow what I order. Thank you. Have a good day. Court calls.
Judge, if I could be heard on bond.
Yes, preliminary examination in person will be set June 17th, 2025, 9 a.m. That is before Judge Moore. Yes, sir.
Judge, Mr. Farrell is here. Obviously, he's in custody. We're asking that the court maybe consider reducing his bond and giving him a GPS tether. He does have a local address. There's an address that I can give to the court over in Ypsilanti that where his father and grandmother reside, and he may reside there as well. He reports also he did obtain a job in Wixom, and it is a full-time job. He reports that he has been in contact with his boss there, and the job is open for at least for the current period. We'd ask the court that the court give him an opportunity to reside outside the jail, either by reducing his bond to a postable number or a personal bond with the GPS tether and any testing requirements and no go-to requirements that the court deems fit to ensure both the safety of the public and his appearance. And the address on Kirk Street in Ypsi is not an address where the complaining witness resides.
So the address you were referring to is the Kirk Street address.
Yes, Judge.
Thank you.
Your Honor, I'm going to object to modification of bond. This case is a reauthorization of existing matter before Your Honor.
Sure.
I have concerns given that in that case.
2 cases, 2 defendants, 2 judges not having it. What do you think? Are these bond denials justified or overly harsh? And should prior behavior always outweigh current treatment efforts? Let's debate below.
He failed to appear back in 2023, did not come back into contact with law enforcement until May of this year, and he was picked up. And at the time that he failed to appear, he had a violation of bond for leaving the state, and also for contacting the victim after he had been released. I had concerns given that there were concerns of previous contact, and then he failed to appear for over a year and had left the state. So I would ask that bond remain the same in this case, Your Honor.
Your Honor, Mr. Farrell is well aware of the importance of this matter, and I would note that he's now charged with a felony. It's a brand new case. This case has been kicking around for I don't know how long. I don't know why it was never charged as a felony back then, but it is now. I'd ask the court for a personal bond or a reduction.
That's the state.
That is my end. That's what I'm informed by the people.
Yeah. Motion for bond reduction or modification is denied. Bond will continue.
Thank you, Your Honor.